All right, guys. Sorry. I had a last minute cut in there. Dakota, I got to figure out where to add you here, brother. Sorry. I had a last minute cut in there. Dakota, I got to figure out where to add you here, brother. Sorry. I had a last minute cut in there. Dakota, I got to figure out where to add you here, brother. Sorry. I had a last minute cut in there. Dakota, I got to figure out where to add you here, brother. To add you here, brother. Tonight. I am on TikTok once again. We're going live every single night now on TikTok so that we can start to get some of these questions answered. We are absolutely uh, in these final stages. We're in the mass push right now to pull this together. It's do or die at the moment. So because we have such a massive amount of pressure that exists because of the campaign cycle, and some of the videos that I put out here recently explains exactly what it is. But we have a lot of pressure right now, a lot of opportunity to be able to change this system around. So Facebook, I will be doing some lives for you guys as well. If you guys want to switch over to TikTok, if you have it, then please do. And Dakota will be able to answer any of your questions there. Okay, guys. Um, okay, so okay, Dakota, you're not on yet. He's not on yet. So, guys, there you are. There you are. All right. Okay, guys. Okay, there you are. Okay. Um,
Peace, brother. How are you?
we have four. I'm good. I'm good. So everybody, again, this is Dakota. He's up in New Hampshire. He's a brother of mine. He's going to be the moderator. And but tonight I want to start with explaining my particular background, if I could, please. Is that all right, Dakota?
Absolutely. Go.
Okay. So guys, again, my name's Tan Woodowning. I'm a civil rights advocate, litigator, and I'm here in Washington D.C. So My education is in what's called substantive law, right? It's not in adjective law. I don't have a degree in administrative law. So attorneys, they go through what's called adjective law, right? They learn about the adjudication process. They learn about how to make a person into a slave. They learn about how to make a person into a criminal. That's what they learn. They learn all these laws that remove freedom, like statutes, ordinances, customs, judgment rulings. They learn about all these laws that remove freedom because that's what they're in the business of. They're in the business of removing freedom. And so they learn about the adjudication process. They learn about administrative law, which, as we know, not just from last night, but from what Justice Gorsuch is going around talking about, administrative law is not law. So when you consider what administrative law is, let me lay it out real quick here. So when you consider the three branches of government, okay, so Clause 1, Article 1 of the Constitution for the United States of America, it says all legislative power is vested in a Congress of the United States consisting of a Senate and House of Representatives. So that means all power to make law is vested in the legislative branch. The people make the law through the Congress of the United States. So only the people create law, only the legislative branch creates law, and that would be, the separation of powers. Now, the second branch is the executive branch, and they are there to enforce the law, right? Enforce the law. They don't create law, they create orders, and orders only affect those that are being ordered. So the true reality is that an executive order only affects the people within the executive branch because the president can't order the people because the people are the master, right? So executive orders only affect those that are being ordered, but it's not law. The executive branch has no authority to create all law because all legislative power is vested in the Congress of the United States, the legislative branch. Now, the third branch of government is known as the administrative branch, the judicial branch. They are there to administer the laws, right? And so when you consider the fact that if the administrative branch creates a ruling and then calls it law, called case law, then that would be administrative law, right? But the problem is that judges and the judicial branch don't create law because that would be a separation of powers issue. They create rulings, right? Rulings. They don't create law. Exactly. Well, we switched to admiralty law, but we'll circle back to that. In fact, Dakota, circle back on the statement on administrative law there. So when the administrative branch, the judicial branch, creates case rulings, right, and then they call it law, that would be unconstitutional because it's law that was created by a branch of government that has no authority to create law, and therefore what they created was unconstitutional. Refer to Norton versus Shelby County, United States Supreme Court. A law is unconstitutional, and it's not unconstitutional from the moment that it's deemed unconstitutional, but rather from the moment that it was created as though it was never even created at all, because it has no force or effect. It's nothing. It's absolutely nothing, as though it doesn't even exist. So when the judicial branch creates rulings and calls it law at our foundation, and then the judges say, well, we decide what the law is. We make the foundation. We direct all the judges in the country to follow that law. Well, that's not law. That's a lie because judges don't create law. That would be legislated from the bench. That would be a separation of powers issue. The judicial branch has no authority to do it. So an attorney, according to the corpus juris secundum, it states that attorneys are administrative officers of the court, right? Administrative office. They learn about administrative law. So when the judicial branch creates a ruling, calls it law, and then the states choose to rely upon something that is not law to create their statutes, such as they did in, say, a driver's license, or such as they did in tax. When the states decide to create their own statutes, their laws, when they rely upon something that is not law, called a judge-made ruling, even though it was called a law, it's not law, then that means that statute created by the state is void, absolutely void. It's not real because it was created based upon something that was unconstitutional. Therefore, it itself is unconstitutional. So when you have the administrative branch thinking that they can create law, right? Think that they can amend the Constitution of the United States based upon their own social, political, public policy, that would be a completely erroneous assumption. The judges cannot create law, nor do they have the authority to alter, amend, or destroy the Constitution of the United States. So attorneys are part of the administrative element. That's why they follow case law, is because that's what they're taught. They're administrative officers of the court. Now, my degree is in substantive law, okay? Substantive law. The only thing that I learned was the Constitution because I'm in enforcement, right? Law enforcement. That's what substantive law is it the enforcement of the law. So so attorneys learn about judges, right? And about everything judges want them to know. I learned everything that there is to enforce the law. So so what I do is I build a case against people and I determine the truth. I'm known as an advocate. I'm not an attorney. I'm an advocate. I speak on behalf of others, particularly in a legal matter, and that's what a prosecutor was meant to do. You see, a prosecutor should not have a degree in adjective law because if they do, then what happens is that the only thing that they know how to do is make this person into a slave because that's what they've been trained to do. So they can't look at someone neutrally and unbiased to say, well, was a crime even committed? Was there mens rea? Were there elements of crime? Is so they don't have the technical expertise that's necessary to actually determine truth because they haven't been trained in the elements of truth or the elements of a criminal process. So I deal with criminal matters. I know criminal law. I know investigative process. I know the Constitution. I have the type of degree that a prosecutor should have because my goal is to determine the truth. My goal is to administer justice, whichever way that might be. And so the things that I'm doing, you guys, is focused on the criminality of our government, which is resulting in the criminality of the people. Because if our government are criminals, then they're going to lead us toward criminality, which will produce a society of criminals. And a simple assumption of law is that you cannot break the law in order to enforce the law. So as long as our government is acting unlawfully, committing crimes, and they're criminals, then that means that they're going to lead our country toward criminality. So we can't have a conviction that exists when our government is breaking the law in the pursuance of that conviction. Because by the breach of the law, by our leaders, it results in a breached outcome. So you can't enforce the law, break the law to enforce the law. So I don't know about the process in a courtroom. I don't deal with courtrooms. I deal with if you want someone arrested, I know how to make that happen. I know how to investigate. I'm as good as they get. I have a master's in forensics. I have a master's in substantive law. I have a master's in information security. I know how to build a case, how to investigate it, and how to make it so tight and complete that they won't get out of it. So that's what I do. That's why everything that I'm focused on is the criminal aspects of this matter. So what we're doing right now is if I can show the criminal element or the criminal acts that have been committed by the agents of government, then by showing their breach of constitutional obligation, by showing their criminality, then I'm able to void or render void all of the action that they produce. So if a judge, or sorry, if the Supreme Court of the United States creates a ruling, administrative ruling, right, and then calls it law, which again is unconstitutional, and then they direct the states to follow their unconstitutional ruling that they called law, and then the state created a statute that says, okay, we don't have to do this because this ruling said we don't have to do it. Well, that law is unconstitutional. And therefore, all of the contracts that are created by that unconstitutional law would all be void if the law is deemed unconstitutional. So let's go back to 1833 real quick. 1833, the United States Supreme Court comes out in a case called Barron versus Baltimore, and they declare that the Bill of Rights are not a restriction against the states, only a restriction against the federal government. And as of that moment, nobody has the right to an indictment by a grand jury in accordance with Clause 1 of Amendment 5. Nobody. So if that's true, then all the states said, oh, great, we don't have to have an indictment by a grand jury. So they all created laws within their inferior constitution that says, we're not going to do a grand jury. We're not going to have it. Or we're going to allow our prosecutors to do it by their discretion, which either way is unconstitutional because it's relying upon something that is not constitutional in order to produce your law. And that would make your law unconstitutional, which means that all these convictions, which are nothing more than a contract, all these convictions that derive from that unconstitutional law, if I can remove the unconstitutional law, right, then all of the convictions that are presented to it, everything that relied upon that inferior unconstitutional law must also be removed. Must also be removed because they're all tainted by the illegality of the way in which they were obtained. So until the highest court in the land comes out and corrects its ruling from 1833 and directs all of the courts to act in a lawful constitutional manner, then the things that they produce is going to be unconstitutional because the highest court in the land committed fraud and introduced that fraud that permeated to every single court across the country. So if every court in the country is relying upon a fraudulent ruling, an unconstitutional ruling that was called law by the highest court in the land that directed all the courts to do something unconstitutional, then that means that nothing that these courts are going to do is going to be constitutional until the highest court in the land corrects that and directs all the courts to act in a lawful constitutional manner. So all these convictions all across the country are all void, and it is the Supreme Court of the United States' fault for it. Their fault. They're responsible for it. It's no one else's fault but theirs. They did it. And so at the end of the day, I want you guys to know, I'm not saying that anyone is innocent. I'm not saying that anyone is good. I'm not saying that anyone hasn't done horrible, horrendous things. But what I am saying is that they're not guilty, because guilt is a process. You must follow that process. And if you don't, then you cannot declare guilt. If the acts of government is unlawful, then what they produce must also be unlawful. If you're acting outside of the law, Supreme Court, and you're not following the supreme law of the land because you feel as though you have the authority to alter, amend, or destroy the law, the Constitution of the United States, then I'm going to say to you, everything you should do until you decide to comply with the established rule of law, the very law that your institution was created to protect and defend, that you have now become a willful accomplice in destroying, until you decide to obey the will of the people, nothing you produce is going to be lawful. Nothing. Absolutely nothing. So we're in a very, very good position right now, because all of this, every law, everything I'm saying, 100% valid, and it can be read, and you can all read it. Clause 1 of Amendment 5 says no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury. That's clear. You must have an indictment by a grand jury. Therefore, when all of these states rely upon a judge-made ruling from 1833 to say, I don't have to give you an indictment by a grand jury, and as a result, there's more than 700,000 people sitting in prison that never received what they're entitled to based upon the Fifth Amendment, then guess what? Until the highest court in the land corrects it, directs all of the courts within its purview to act constitutionally lawfully, corrects the unlawful ruling that they called a law, which was unconstitutional, until they correct that, it's the Supreme Court's fault. They did this, guys. It's their fault. The whole system that they built, every single thing that they've done, their predecessors have done, all of them is completely without force or effect. It's all bullshit. It's not real, because that institution has never, in the history of its existence, ever followed the will of the people, because they're in the business of enslavement. So again, going back 2 days ago, and I'm almost done, Dakota, but going back just a couple days ago when I said that of the first 28 justices that served on the Supreme Court, 22 of them owned their own slaves. So if the Supreme Court of the United States, if 22 of the first 28 justices on the Supreme Court own their own slaves, do you think that those men wanted the slavery institution to go away? No, not at all. Okay. So if that's true, then when they created rulings and called it law and placed that at the foundation, then we wonder why we have the slavery institution in existence today. Because the foundation is not based upon the laws that set free, not based upon the will of the people. It is based upon the desire of individuals that want to proliferate and protect their institution that we call slavery. And we can see all throughout history here in America what it actually is, because our founders and forefathers, they made a huge mistake when they first started the country. They started an egalitarianism form of government, which is the belief that all men are equal. And when you start an egalitarianism government, you must have all men actually be equal. Because if you don't, then you create a system that has the ability to perpetually discriminate. And that's exactly what we have. You see, when all men are equal, but our founders and forefathers refused to give up what they called their property, right? They didn't create a just system, because it's not built upon just principles. They created an enslavement system because slavery is and always will be the foundation. So we need to fix the foundation. We need to remove what slave owners created and place the foundation unconstitutionally, because they had a desire to proliferate and protect their property We need to remove that. We need to put the laws that set free down at the bottom. And when we do, then we shall be free. But when you have the Fugitive Slave Act, right, we can see that a fugitive is a slave and a slave is a fugitive. Now we know what they're talking about. When you go to the 13th Amendment, the very amendment that was enacted in order to abolish and destroy slavery, it did nothing of the sort. Nothing of the sort. Not only does it permit slavery, but it actually codified the legality of it within our foundational law, because it doesn't say you can't have slavery. What it says is it says neither slavery nor involuntary servitude shall exist except as a punishment for crime. Well, the moment you say except, it means that you can't have slavery. But we call it justice here in America. So what we did, the truth is that we simply took something, we retitled it something different. We changed it from private institution to a public institution, and we told America that it doesn't exist anymore. And I'm going to tell you right now, it does. That is why mass incarceration exists. That's why we've seen an 800% increase in the prison population in the last 30 years, is because this industry has been placed in our foundation through judge-made rulings that was called law, where they removed the Constitution, the laws that set free, and placed their own desire to protect their property at the foundation, illegally, unconstitutionally, and outside of the will of the people. So there we go. Go ahead, Dakota. Let's get into some questions here, guys.
So, for any of you out there who have a question for Tanawa, right now in the chat, and I'll read the question to him.
Thank you, James.
Like the information that you're hearing so far, what has sparked within you? What type of question that you have that you need an answer to? Maybe we can help you.
If we could go back to the Admiralty statement, I'd love to just explain, where we went wrong on Admiralty law, where that comes from. If that's a question that you guys want to hear.
Yeah, let's circle back to that. Give them time.
So awesome. So in the Constitution, it identifies two different types of law jurisdiction. It identifies common law jurisdiction, and it identifies Admiralty jurisdiction. Now, Admiralty jurisdiction deals with contracts. It deals with contract law. That's all it is, just contract law. Now, a little history behind our country, a little history behind the whole Admiralty jurisdiction thing, and some of you guys are gonna learn a little bit about some word entomology here, but going back to the founding of our country, right? 1628 and the stamp tax. Okay, so we had the stamp tax, which led to the Boston Tea Party. If you guys aren't aware of it, it was extremely unpopular amongst colonists. They hated it, right? They hated it because it was taxation without representation. We didn't have the ability to say, oh, no, we don't want this tax, because we weren't represented in the parliament. And so as a result, we were being taxed without our ability to be able to say, no, we don't want to be taxed. It was taxation without representation. And so what happened in 1628 was that the stamp tax came through and nobody would find anybody guilty of it. So people kept getting arrested, kept on, coming into a trial, and the jury would not find anybody guilty. The jury of the colonists would not find anybody guilty of this particular offense. And it made the king mad. He's like, well, okay, if you guys aren't going to find anybody guilty, then I'm going to eliminate your ability, and I'm just going to have my officers be able to operate arbitrarily, right? So what happened back then was that the king switched us from common law jurisdiction into Admiralty jurisdiction. And the reason why is because in Admiralty jurisdiction, you don't have the right to a jury trial. In Admiralty jurisdiction, it is a court martial. It's the same thing that was going on down in Guantanamo Bay in 2004 with Rachel versus Bush, right? And so what happens there is that the allegations come in by an agent of the state, a prosecutor, whatever, and they bring the accusation against you. You're presumed to be guilty, and then they bring you into this sham process where the judge acts as both the judge and the jury in this process that they say is valid. It's not valid, but that's what Admiralty jurisdiction is. It allows for the king's agents to be able to bypass the fair and neutral decision maker of a jury to be able to do whatever they want, right? To be able to tax you and win. And so, Thomas Jefferson, he wrote about this actually 3 separate times within the Declaration of Independence. One time he said that we are subjected to a jurisdiction that's foreign to our laws, right? So we were subjected to Admiralty jurisdiction, which was foreign to our laws. That was a statement that he made directly in the in the Declaration of Independence. Another reference was where he said that in most cases we're not provided a trial by jury. And so both of those had to do with what was going on at the very time there, because because they knew that by this switch, what the king had done to us, it caused us to be shifted into a different jurisdiction, and we were then denied the right to trial by jury. Now, you guys, that's what information is. That's what it is. Because when you're charged by information, not by indictment, that means that the state becomes your accuser, right? The state is bringing the accusation against you through one of its agents. And when the state becomes the accuser, then the judge and the prosecutor, they both work for the same investigators of law enforcement. They all work for the same thing, right? I'm not saying that this is valid. I'm saying that it's not valid, but I'm telling you just the history behind this, you guys, so that you can understand where we got to where we're at today. So admiralty jurisdiction is not supposed to be within any criminal adjudication process. It's not supposed to be. And the reason why is because you guys know about the fringe around the flag, right? So the yellow fringe that we place around the flag, it indicates that it's a battle flag. It's an at-war flag. Right? That's well known. When you look at the history of England, the history of battle flags, you'll see that when you place a fringe around the flag, that is a battle flag. Okay, and so it means that you're in a battle condition. It means that they're warring against the people. That's why we're at war against the government and the public officials, because they are warring against the Constitution, because they have placed us into a state of battle. And so they placed the fringe around the flag. Now, our founders and forefathers, they knew that the moment you place a fringe around a flag, your right to trial by jury goes away, which is why almost every single state constitution, if you read them, especially the state of Massachusetts or the state of Virginia, it says the right to trial by jury shall not be infringed. Shall not be infringed. That's where that word comes from. Because when you infringe a flag, your right to trial by jury goes away. Our founders knew that. That's why the right to trial by jury shall not be infringed, because the moment you place a fringe around a flag, your right to trial by jury goes away. Okay? So, no, you're not supposed to be able to infringe a flag, and yet here we are in the infringement of the flag, and so as a result, we know that we're in admiralty jurisdiction, and they are operating without lawful authority. Now, the things that we have, so what is the remedy? The remedy is we have to follow the Constitution, because when we charge by way of information for a criminal adjudication, we're in an infringed state. Our right to trial by jury goes away. That's why the Constitution states in Clause 1 of Amendment 5, no person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So the Fifth Amendment was put into place to make sure that all of you are guaranteed the right to trial by jury. Our founders were very, very intelligent men. What they created was a very, very robust document that protects us in ways that we can't even imagine, because of very simple words. I brought up the whole billing situation last night, where the bill of indictment derives from nobility, right? And if you are nobility, it means you can't be billed for a crime. These are the origins of these words. The infringement of the flag is the right to trial by jury shall not be infringed, right? These words have meaning and source, and our founders were well aware of it, and we can actually relive and understand these things as we are. So the right to trial by jury shall not be infringed, and the way that they protected us from infringement is by saying no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So there must be a neutral, unbiased third party there to review the state's accusations, and the accuser must be given the right to be able to defend themselves against those accusations in that grand jury. And if they don't, then that's charged by information, which means that the government has usurped its power and decided that they're not going to proceed in a duly prescribed manner by providing you with a due process that you're entitled by the procedure of the process is codified in the Constitution. And so now we have a complete breakdown of the system because the system isn't functioning right. Now, I'm going to tell you guys, one last thing here. In 2004, Guantanamo Bay, right, we were bringing all of these enemy combatants, all of these war on terror, enemy combatants, we were bringing them to Guantanamo Bay, Cuba, right? And we were bringing them through these same sham trial processes. And so in 2004, The ACLU brought a whole bunch of cases, a whole bunch of writ habeas corpuses on behalf of these prisoners that were being uh, held down there in Guantanamo Bay because they weren't being given the right to a fair trial process. They weren't being given the right to confront the accusations against them in a neutral, unbiased proceeding. And what is particularly egregious and the reason why I want to bring this up to you guys is because in 2004, the ACLU stepped up to stand up for prisoners that were suspected terrorists. And yet today, however many, 18 years later, United States citizens are not guaranteed the very rights that they fought for enemy combatants and foreign nationals and suspected terrorists. And they're not fighting for us because this is the exact same issue. The exact same thing that the ACLU fought for on behalf of a suspected terrorist down in Guantanamo Bay is the exact same issue of the absence of indictment by a grand jury. It's the exact same issue. And so the Supreme Court of the United States came out and said that enemy combatants, any one of these people, many of them are not United States citizens, many of them, all of them, all have the right to every single protection and immunity that the Constitution of the United States provides, every single one of them, including the right to be able to go in front of a neutral, unbiased decision maker to present the accusations and hearsay evidence that's against you. But they did not say that United States citizens are guaranteed those rights simply because different states decide that they want to do whatever they want to do. So here in America, United States citizens and us, the people that live here, indigenous to here, we don't get the rights that enemy combatants get. And it just doesn't make sense. So what they did in 2004 is the same argument that I have right now. And we're going to prevail on this, but we got to get this information out. And so that's the history behind the whole information. But we switched into admiralty jurisdiction in 1933. When the United States of America went into bankruptcy, that's when they shifted us into admiralty jurisdiction because bankruptcy is a contract issue, and they state that because we're in bankruptcy, as long as we're in bankruptcy, we can operate in admiralty jurisdiction. That's what they claim. And so that's one of the reasons why I say we need to finalize this bankruptcy. We need to get it done because we cannot operate in admiralty jurisdiction because they didn't have authority to be able to shift this, to subject us to a jurisdiction foreign to our laws. We have the same arguments, the same claims that the Declaration of Independence and Thomas Jefferson would have had, 243 years ago. And so, that's when we switched, 1933. That's when they moved us into admiralty jurisdiction. They did it under the whole bankruptcy umbrella. And as a result, our rights are being significantly deprived as a result of their desire to advance the business of enslavement. So thank you guys so much. No, bankruptcy wasn't done. We're still in bankruptcy. It's not over yet.
Okay. So I have a question, Taylor. You mentioned earlier about misdemeanors that are, less than a year are not infamous crimes. So what would one do with handling such a case that only time up to a year?
You're not supposed to go to jail for less than a year. Those supposed crimes there are not crimes against people. They're not. It's a driving infraction, right? Well, driving infraction is a civil matter. You didn't injure anybody, so you don't have a license. Great. So the reality is the reason why you wouldn't have to have an indictment for non-infamous crime is because you were never supposed to go to jail for those crimes. You're never supposed to go to jail. I mean, so we have a number of issues that exist, but at the end of the day, the big problem is that the only reason why people are supposed to be locked up is because they've harmed someone else, right? And they're a danger to society. We're not just supposed to lock people up because we want to force them into involuntary servitude so we can, profit off of the work that they do and the products that they produce in an institution we call a sweatshop in China, but a prison here in America. That's not what the prison system was meant to be. It wasn't supposed to be a punishment. It was not supposed to be punitive. It was meant to be a restorative system. So some of these questions I can't answer because I don't know some of these, but the reality is that if it's not infamous, you were never supposed to go to jail,
Okay.
right? You're only supposed to go to jail for an infamous related crime because those are crimes against the person. But when you have a crime against a corporation, you weren't supposed to go to jail for that. You weren't supposed to. And so, but so if you look at the particular offenses, and I thought about this morning. I was walking down the street and I saw this cop writing a ticket. No, what it was, I was walking in the metro and someone had jumped over the rail, because he didn't have money to pay. Great. Well, and he jumped over the rail and a cop came up to him and decided to write him a ticket for this. And I thought, wait a second, that's a civil matter. How is this law enforcement officer enforcing civil law? Law enforcement can't enforce civil law. That's civil law. So when a police officer pulls you over on a civil matter, because it's a civil matter, if you're not harming anybody, you don't have registration, you don't have life. How can law enforcement enforce the civil law? I mean, they come to your house, they're like, well, there's nothing we can do about this because, this is a civil matter. We can't do. Well, how are you out there pulling people over then? Because that's a civil matter. It's not a criminal matter. It's a civil matter. I mean, so there's a number of different things that we have to address, and I don't have that particular answer other than the fact that you were not supposed to go to prison for a non-infamous crime. You weren't supposed to.
Okay.
You weren't supposed to be in jail.
Okay.
Yeah.
So I have a question, Taylor. Taylor said, the police, county legislators on notice.
Yeah. So I put all three levels on notice, right? Whether or not they agree with it is irrelevant. But when I served the state attorney general in 33 states by serving their agent, by serving an assistant attorney general, right? I did that in May and June of this year. When I went and I served an assistant attorney general, that is an agent of the attorney general. When I served an agent, notice to agent is notice to principal. You guys, all the videos for this is all on my TikTok. You guys can go out and you can see all these videos. They're all available to you. Both the service on the Attorney General as well as the service on the Supreme Court, all these states, go out. I would highly recommend that you guys watch the one on Rhode Island, watch the one on Florida, and watch the one on Virginia. I think that those are probably the three best ones. Rhode Island is by far the best, I think. But New York is very good as well because I do a good summary with President Trump. But I would highly recommend that you guys go out and watch that. But I served all the states, all that information, all the videos available. You guys can watch it, download it, share it, whatever. If you live in any one of those states, you guys, your work's done. But when I served the Attorney General, the highest executive officer in the state, notice to agent is notice to principal. But notice to principal is notice to agent. So the moment that I notify the top law enforcement officer within these 33 states, he has a duty and responsibility to take action. And if he fails to take action, then he is permitting the unlawful acts to continue. He's permitting his agents to continue to break the law, which means that now they're all notified. Every single one of them are on notice of the criminal acts. You don't have to serve every single one of them when you can just go to their boss and serve their boss. Because if their boss does not do what he's lawfully obligated to do, they're all notified. Done. So I went through and I served the 33 state attorney generals by serving an agent of the attorney general. Then in late July and August, I went and I served the same 33 state Supreme Courts by going to the clerk of the court and serving the exact same notice to them, right? And by serving the agent of the Supreme Courts of these states, now once again, the principal has been notified and he has an obligation to take action to correct the unlawful acts or the criminal acts of his agents by directing them to act lawfully. And when they fail to take action, then that means that the Supreme Court, the highest judicial officer, is permitting and sanctioning his agents to continue to break the law. So as of that moment, we've notified every single judicial officer in 33 states. We've notified every single executive officer in 33 states. That's 2 branches of government. The only branch of government left to be notified is the legislative branch, right? Because there's only 3 branches of government. I've notified all the executive officers by notifying the highest executive officer. I notified all the judicial officers by notifying the highest judicial officer. Now we have to notify the legislative branch. That's why I'm here in DC. That's what I've been doing for the last few weeks. I've been going around to all of these buildings here to the Rayburn building, to the Russell building, to the Hart building, all of them. And I've gone through and I've notified every single one of them through their agents, because their agent is whoever I walk in the door and I speak to, because they're there to receive on behalf of. And I'm now notifying them. Here's what we did. Here's the criminal acts that are being committed by your state against your constituents. Now you've been notified. I walk out the door and it's done. Now they have an obligation to take action. And when they fail to take action, guess what? There isn't a single public official in any one of those 3 states now that has not been notified. Every single public official has been notified. So now every single public official is now opposing party to this. I have made every single public official now opposing party to all of you. All of you. Not one of them, unless they decide to act lawfully by their own honor and step across, enforce the law, get onto my side and start enforcing the law lawfully. Unless they do that, they're all criminals. And I can show that they're all criminals. I can show all of you, every single one of you. But that also means that no state court within any one of those states can adjudicate this matter, because they're all recused. Every judge is recused. The state Supreme Court's, every one of them is recused now, and none of the attorney generals can act on behalf of the people to represent the people, because they're all recused now, because they're all in criminal act and criminal actions against the people. So now we got to say, okay, who can represent the people? That's what I'm doing. I'm going to represent the people. I'm going to come in as a private attorney general, and I'm going to deal with prosecution. And what court can adjudicate this crime? Well, the only court that has jurisdiction in the case anyway, according to the Constitution, which is the Supreme Court of the United States. No other court can oversee this. No other court can deal with this, because every other court has now been recused, and no attorney general can deal with this. The solicitor general can't do it because he's opposing party, because any counter argument that anybody gives me, any counter argument would be seditious. The solicitor general has already said that if this comes forward, he's not going to argue it. He's going to call in sick, because he can't present a counter argument to this issue without it being sedition, without him saying, oh, we're not going to follow the Constitution, because that's the only argument that they have. Here's what the Constitution says. I want you to do it. And any counter argument to that is, oh, we don't have to do what the Constitution says. Solicitor general is not going to do that. Will not do it. So this is going to go unopposed. But the problem is we have to force it into there. But what I've done is I've eliminated every single public official as of this moment by notifying the top officers of the legislative branch, because highest legislative officer is right here in DC, right here, the senators. I notified every single one of your senators, every single one of them, every one of them, right? So now we've notified the top legislative officers. That means that every legislative officer has been informed, right? Whether they know it or not yet is irrelevant, but they'll know about it soon, And I've gone through and I've notified every single one of the judicial officers by notifying the top judicial officer. It's done. Whether they realize it yet or not, irrelevant. It's done. I have the record. I have the video. You can all see it, And then I've notified every one of the executive officers. I have the video. You guys have seen it. So every public official has now been notified of the criminal acts being committed by state agents. So hope that answers your questions.
Awesome. Okay, so now we have Flocka. Are there any cases? He says, tell me about the cases that a state can be an injured party and the judge can't.
State cannot be an injured party. So the Supreme Court, the state is made up of a body of men. That's all it is. It's a body of men. And that body of men is made up of a whole bunch of different parts. Paul says in the book of Romans, he says that Christ is made up of many different parts, right? And you're all working together to bring about his mission. So don't you know that you're all a member of the body of men, or body of Christ? Well, when you have a state, that's a body, right? And when that state, government can take a side against you, but when it does, it's no different than any other body. So when the state of Washington takes a side against you, then everything that's a part of the state of Washington all works together to advance their interest, right? So the state of Washington is made up of prosecutors, it's made up of CPS, it's made up of judges, it's made up of law enforcement. They're all part of the body of men that make up the body of the state of Washington. But the state of Washington is one body. When it comes as a party and says state of Washington versus you, that party is made up of all these people. So the way that criminal conspiracy works, the whole theory behind it as an inchoate crime, it goes like this: that I'm made up of a whole bunch of different parts. I have hands, I have arms, I have legs, I have eyes, all these different parts that make up the body of Tanner, right? So if my hand goes out and it steals something, then my head can't say it was my hand that did it. You can't punish me for it. No, no, no. My head's part of the same body. If my hand steals something, my head has to pay for it, right? If my foot assaults someone, my hand can't say, "Oh, it wasn't me." I'm not responsible. No, you are responsible, right? So now this concept of conspiracy comes into play because if any part of my body injures someone else, then by that injury, all parts of my body must pay for any one act of any one member or agent. And now take in the state of Washington, right? If one part of the body of men that make up the state injures someone, then that judge can't say, "Oh, it was the officer that did it. You can't punish me." Oh, no, 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 no. That's not how an inchoate crime works, right? You are part of the body of men. So if you don't want to be responsible for the unlawful acts of that officer, then what you must do, judge, is you must step up and say, "Officer, I'm going to hold you accountable for your crimes." And if you don't, judge, then you have just established a part of the conspiracy. Because if you know about a crime that's being committed and you choose to do nothing about it, you may as well be the one pulling the trigger, judge, because you knew about it, you permitted it to continue. That's where criminal conspiracy comes from and the theory behind it. So the body of men that makes up the state, it cannot become the accuser against you, because if it does, then all the men that's a part of it have to recuse themselves because they all work together. So a judge cannot, a state can become a party in cause. If it wants to, it can. But if it does, then no agent within the body of men that make up the state, none of those agents can act as the judge. None of them. Because no man can be both judge and party in the same cause. No man can judge his own case. So if the state does want to become a party, that's fine, become a party state. But if you do, you lose your right to be able to judge that case because the judge has a constitutional obligation to recuse himself, codified in Article 3, because he has a conflict of interest. He works for the plaintiff. That's why James Madison said in the Federalist Number 10, right? He said in the Federalist Number 10, and this is the earliest known reference to the modern day concept of conflict of interest. So today we call it a conflict of interest. The whole concept of conflict of interest derives from this particular statement from James Madison out of the Federalist Number 10, where he said, "No man is allowed to be judged in his own cause, because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time." So no man can be judged because his interest would no doubt bias his judgment. Conflict of interest, because his interest would no doubt bias his judgment. That is the earliest known reference to the modern day concept of conflict of interest. That's where it came from, is James Madison pointed out the fact that, guess what? You cannot be judge in your own case because the body of men that make up the state cannot be both accuser and judge. States were never, ever, ever meant to be both accuser and judge in the same cause because of the bias, prejudice, and partiality that would ultimately transpire as a result of it. States cannot be both judge and party in the same cause, because if they do, innocents will suffer, such as they are today.
Thank you for that question, and thank you for that answer. Got Dr. Money. Dr. Money said, "How do we administrative law because it's administrative?"
How what? Say one more time, I'm sorry.
How do we remedy administrative law because it's administrative?
Okay. So that's what we're working on doing. And you guys, we have Justice Gorsuch already on our side. He's already on our side because so what happened was that last September 29th, I filed a writ of assumption to the United States Supreme Court here in Washington, D.C. on behalf of the people of the United States. I brought up this exact same issue, this issue, that when judges create rulings that are unconstitutional, then everything that's produced from reliance upon that judge-made ruling is going to be unconstitutional. It was a huge, huge deal, and the court didn't want to hear it, right? So they asserted their discretion and said, "We're not going to hear this case because we have the discretion to not hear it," which is true because I pointed out Article 3. We're going to follow back up, but the thing is like I'm not worried about the court because just as I did over Christmas. So last September, I submitted the writ. Immediately, the clerk of court refused to docket it. Refused to docket it. That's why it never got on the docket. Is because the clerk of court said we aren't going to docket this. I didn't want to fight with him and argue with him because ultimately the decision will come from the court, but the battle is fought in the opinion of the public. So just as Gandhi said, he said that it's not the oppressor that needs to hear the truth. He already knows it. He's busy concealing it. It's the oppressed that needs to hear the truth, and not the oppressor. So we don't need to go out and waste our time trying to tell criminals to stop committing crimes because they're criminals, right? I mean, I can't tell a scorpion not to sting me because he's a scorpion, right? So if I try to expect that I can go to a courtroom to a criminal, be it a judge or a prosecutor, and say, "Hey, you guys need to stop being criminals," I'm crazy because the criminal's not going to stop being a criminal because they were criminal, right? So this was I needed to get it filed. The obstruction of justice exists absolutely by the clerk of court on September 29th when the Supreme Court clerk refused to docket it. But I wasn't going to deal with that issue now because I had a lot of people that needed to hear about this. I needed to get out to the people. I need to spend as much time sharing this with all of you, trying to build the momentum. And the reality is that like this, what we're doing right now, you guys are getting me ready for this argument. That's what this is all about. It's every bit as much about answering your questions as much as it is. You guys are going to get me ready, right? Because this is about the argument. We are that close to this being argued, and I need to get polished up. I need to get right. So you guys are going to help me get ready. And so that's what we're doing here. That's what God's got going on here. Is that He needs me to get these final touches onto this argument prepared so we can kick their living ass. Okay, so that's what we're doing. You guys are going to prepare me and get me ready through all of this every day, coming in and talking about this over and over and over again, so that I'm ready to go in there and they're not even going to present a counter argument. But what happened then was September 29th, I filed the writ. They refused to docket it, obstruction of justice. So then Christmas, I was going around to the district courts trying to convene a grand jury, trying to make this happen, trying to figure out some way to break this free. And I just got so fed up because the courts were all refusing to docket the paperwork that I had. They didn't want to hear it. And so they were just refusing outright to docket it. So on 2 days before Christmas, I was near Las Vegas. I went to the United States Attorney's Office in Las Vegas. I sat down with the U.S. attorneys there, and I said, "Listen, this is the last time you're going to hear from me. The next time you hear from me, I'm going to be walking to the Supreme Court with 500,000 criminal affidavits on behalf of people in the United States for these affected parties. I'm no longer going to work within the rules of a system that doesn't follow its own rules. I'm no longer going to ask criminals to stop committing crimes. I'm no longer going to communicate with you or work with you. I'm going to now go out to the people." And that's what I've been doing. I have no interest whatsoever in filing any paperwork with any court because the next step is I'm going to walk into the Supreme Court with 500,000 criminal affidavits from all of you, right? We're going to drop them in the middle of that courtroom, and we're going to say, "Okay, Supreme Court, what do you want to do about this now? Because we've served all these states. We've shown all this. Now, let's go ahead and slam them with all of these criminal affidavits." I mean, potentially, I could have 70 million because there's been 70 million people that have been illegally and constitutionally charged with a crime by the United States justice system. But I said 500,000. Maybe that number is a little bit low in what I want to shoot for. But that's what I told him. So that's what we're going to do. Yeah. So to answer that question, the affidavit is going to be it has to follow the same form. It has to be exactly the same. So the photos, if you go out and watch the videos of all the services, whether it's a service with the Supreme Court, whether it's a service with the Attorney General, they all have the photo of the affidavit that I served on behalf of because we only did 1 or 2 in every state. I didn't want to bring a whole bunch of attention to this because if I did, they would have shut it down. They would have been threatened. I needed to just go across the states and just do this nice and quietly. And that's what I did. Because once they're served, great. It only takes one. If I can show that there's one criminal conspiracy, even though there's 10 million others, if I do one, they've been notified. That's enough. But one isn't threatening. 100,000 is threatening. So I didn't want to be threatening in the beginning, so I came in with just a minimal amount. If I serve one, that's enough. That's more than enough. So that's what we did. We brought a very, very minimal amount. Now we want to build these numbers up. But the affidavits have to be the exact same form. They have to say the same thing. You don't add anything else into it because all that you do is you point at their crimes. You don't talk about anything about what you did. You don't talk about anything that they did to you. All that you do is you say that on this date, on such and such date, at such and such time, this prosecuting attorney did deprive you, victim, of rights secured by the Constitution when they charge you by information, not by indictment, as required by Clause 1 of Amendment 5. That's item A. That's the first crime. That is the deprivation of rights under the color of law. When the prosecutor charged you by information and not by indictment, that is the first crime. The second part is on such and such date at such and such time, this judge did conspire by and between the prosecuting attorney and the officer who performed the arrest to deprive you, victim, of rights secured by the Constitution when they charged you by way of information, not by indictment, as required by the Constitution of the United States. That creates the conspiracy, and now that's all that's necessary. You don't need to say anything more, because by the establishment of the conspiracy, because of the base crime deprivation of rights, that in and of itself is enough to negate everything else after that. Everything. Nothing. You don't need to talk about anything that they did to you. You don't need to defend yourself against anything that they say you did. All you have to do is point out that on this date, I was charged by information, not by indictment. And on the same day, this judge conspired with the prosecutor and the officer when they arrested me and held me over for this offense without having the proper charges in place. Then there's the conspiracy. So the indictment or the affidavit is only 2 pages long, and it cannot be any longer. This is how we establish the class action suit, right? Because you can't have a class action habeas. And we've already got thousands and hundreds of thousands of people on this habeas. We're going to have millions. But so if you guys do want to get that habeas, it's probably getting on time to do it. I have a website. We have 2 domains, but I have it in automated form. I just haven't uploaded it yet. But you guys, you can all go and you can all see that video and you can all see the 2-page. And you know what? I would have no problem sending it out to you guys. If you guys don't go and serve yourself, get it back to me, okay? Get it back to me and let me handle this because whether I have protection or what, get it back to me here in DC. I can give you guys the address here that we're at. If you guys get it to me, then what I'm going to do, because we've already served the state, so you guys don't need to go back and do anything. You don't need to bring any more attention to this. All we need to do is get the number of affidavits that I want. And when I reach that number, I'm going to walk into the Supreme Court with boxes and boxes and boxes of criminal affidavits on behalf of all of you. I'm going to drop on the floor and say, what the fuck do you want to do about this now? What do you want to do about it now? Because this is on your watch. This is your responsibility. So, and then I told the U.S. attorneys in Las Vegas, I told them that if I come with $500,000, if that's not enough, and you guys still choose to not do anything about this, then that's fine. I will go get 10 million and I'll return with the 10 million because we have the numbers. We can do that. So we can provide the affidavit, right? And you guys can get it to me, and I will serve on your behalf. But it can't have anything else. We can't change anything on the document. It must be exactly the same for every single person. And it doesn't matter what state you're in, it's the same. Now, there's one more thing here, okay? One more thing, and that is that I do not want any of these notarized. Don't notarize any of them, okay? There's a strategy behind that, and I know that a lot of you might say, oh, but it's got to be notarized. You have to. Just listen to me. Do not notarize any of these. None of them. Don't notarize any of them. Okay. Go with what is written in it. Okay. Stick with those 2 pages, and again, I'll have no problem sending it out to you guys. But you're not going to add anything to it. But you're not going to notarize any of these. There's a specific lawful strategy that we have in the absence of the notary. Okay. So one of the don't worry about the 3 witnesses either. You don't need to worry about the 3 witnesses. The reason why, and I don't have any problem explaining the strategy at this point in time because they've already fallen into the trap. So when you deal with a narcissist, because that's what we're dealing with, right? Justice is a narcissist, the biggest narcissist that man has ever known. It's the biggest bully that humanity has ever known, and her name is Justice. Okay, and all of the agents are all narcissists. And when you deal with narcissists, what happens is that there's no self-reflection. They project onto everyone else the insecurities that they have of themselves. So when they call you a criminal, the reality is guess what? I know human nature and tendencies, and I know that when you, liar, call me a criminal, that's because you're a criminal, right? It's projection. They're all liars, every one of them. And if they're all liars, then we know how liars act, and they always project. So when they say you're crazy, well, you're crazy because they're crazy, right? They live in a delusional world, a world that isn't even real, called legal realism, right? That's completely erroneous from what. So they built all these delusions up, and what they do is they then project on you all their own insecurities. So they call you a criminal because they're a criminal. They call you crazy because they're crazy, right? And now we know human nature because that's what narcissists do. And so when we know that we're dealing with narcissists, we know that there's no self-reflection, right? So what you have to do with a narcissist to destroy them is you have to reflect back to them. You have to make them see exactly what they are, right? So the reason why I don't notarize any of these is because how many police officers notarize their criminal reports? When they file a criminal information to the court, when the officer says, here is this information, how many of those do they get notarized? None. Officers don't notarize any of theirs. So if they come to us and say, hey, you have to notarize your criminal affidavits, I'm going to say, great, look at yourself, asshole. Look at what you guys are doing. Because if I have to notarize them, then that would mean you have to notarize them, and none of yours are notarized. So, it will defeat their own argument. If they say that we have to notarize them, awesome. Then by their own argument, they defeat their statement. Great. If mine are void, because I'm only reflecting you, I'm only doing what you do, narcissist. I'm only doing what you do, Justice. And if you tell me that I'm wrong, great. That means that you're wrong too. So we're reflecting back at them exactly what they do. Okay, exactly what they do. We want to do the same thing. That's why when they use state of Washington versus Tano M. Downing, we're going to use Tano M. Downing versus state of Washington. We're going to mirror them in every single thing that they do. Do the same thing over and over and over again. Because when we do, they can't argue. They can't point out something that we're doing wrong without they themselves being accountable for what they're doing wrong. So that's what we're doing. We're defeating the narcissist by mirroring back to them exactly what they are and exactly what they're doing. Okay.
I'm over here answering a couple of people's answer
Okay.
myself.
So what I'll try to do here in the next week, I really need some help, guys, especially with the website. If any of you guys know how to do websites, we've got the domain. I mean, I get the email. We've had the exchange. That's not my technical expertise, guys. It's like marketing. I don't know anything about markets, like news, and I mean, you know, I have my technical expertise, and it's pretty good, right? But it's very very specific. Like I don't know how to break things down small because my mind operates so there's different people that have different types of expertise. Some of you could probably take my 50-page dissertations, break it down to two paragraphs or two sentences, and explain everything, and everybody will be like, "Oh, that's amazing!" And what I can't do that. That's not something I can do. Another thing I can't do is I can't build a website. I don't know how to do it. That's not my technical expertise. But we have a domain. So if anybody's willing to do that and want to help out, that would be amazing. It doesn't have to be great. It doesn't have, but if we could get something out there so that we have a place that people can go. I have the affidavit in jot form, so it's an automated form, and it can be self-populated, and I mean that could bring in a massive number of these quickly. But I'm just letting you guys know that I could use a lot of help from you guys. There's a lot of things that I don't know how to do that I'm not that you guys are, and we all need to find what we do best, what we offer, because some of you guys are whizzes at marketing. Awesome. Take what I got and help me learn how to, because I don't know how to market. You guys do. You guys know how to build a website. So anything that you guys can do to help me at this point in time, if you can take my information, if you can make it shorter, easier, so that it can be more digestible for people, awesome. I will welcome any help that we can get, because we're all going to fill our own part. We're all going to work together to bring about this outcome. I'm only one person in the grand scheme of things, and all of you are a part of it. So whatever you guys want to do, however you can help, let's make this happen. Let's make this happen. Thank you.
I think that to get your people with the website situation, brother, we can definitely talk about that. I got some research on that, but there's also other creative and intelligent people that's out there as well. So, it's all about building a community. All of us coming
Yeah.
So
So to
that's
answer your question, where to get the affidavits? Um, we're going to figure out a way to put it online. So I'm going to tell you right now, whoever has ideas, get in touch with me, get in touch with Dakota. Let's figure out the best way to do this because there is a way to do it. And you guys, we'll figure it out. It's going to be available online. And I'm just going to throw this out there that by this time next week, it will be available online. Somewhere online, you will be able to automatically go out, fill out the affidavit, print it, and send it to me or someplace to receive. And let's put a number on it. The moment I hit 500,000, that's the number I said back in Christmas. The moment I reach 500,000 of those is the moment that this is going to the court. Okay, this time next week, guys.
okay. And guys, listen. As far as it is concerned, let's not focus on doing anything extra outside of what the affidavit provides. So you're only going to fill in the information where it shows that you fill in your information, and that's it. Don't alter
Yeah,
it outside of how it's created,
yeah,
because then you'll be going outside of strategy.
yeah,
There's a
yeah.
strategy to be.
Extreme. Excellent point. The reason why is because you guys, we are building a class action here, and the class action must have every single person be the exact same procedural situation. So if you talk about anything outside of that, this happened to me, I was charged by information, and I was held by information. If you talk about anything beyond that, now you're going into something that happened to you that's outside of the class. We want to bring everybody together because this one issue affects every single one of you, right? That has a criminal offense. Every single one of you, right? I was charged with the incorrect charging instrument, and then I was held by the incorrect charging instrument. That's it. Don't talk about anything else. And when we do that, then we establish the class action group. And that means that if any one of the procedural situation, if any one of the litigants overcome the procedural situation, they all overcome. It's called vicarious relief, meaning that if we have 2 million affidavits, let's say that there's 2 million litigants that come forward because they all meet at the same level. I'm already at the Supreme Court. We're already there, which means that all of you get to bypass every other level that I've already been through and meet at the same level as the petitioner in a procedural situation. The moment you do that, then how it works is if any one of the petitioners overcome the procedural situation, if any one of them win, they all win. All of them win. Every single one of them through vicarious relief. Every single petitioner in the same procedural situation will overcome, which means that if I fail, great. There's going to be 2 million people behind me, right? One of them is going to win. And one of them is going to win, right? And any one of us can win, right? I may not be the winner. Maybe someone else got a better argument. But regardless, if we all come with the exact same argument, I was charged by the incorrect charging instrument, then I was held by the incorrect charging instrument. By talking about that, every single one of us has the exact same argument. No change whatsoever. And that creates the class action habeas. And once we have the class action habeas, that's where the power comes from, guys. Massive power that's gonna come forward, right? This is how we organize to overcome. This is how we organize to beat the system. So just like Dakota said, you do not want to change the affidavit. But the other point that I want to stress here, the other very, very important point that I want to stress here is do not do anything except for return it to me. Guys, don't take this into your prosecutor and give it to him, okay? Don't take this into your judge and give it to him. Don't take it to the Supreme Court and give it to him. Don't do that. Don't, because what's going to happen there is that we will be labeled rebellious, right? Or some of you might get upset and get confrontation. Any number of different things could happen that could label us as problematic, which would give them the right to be able to shut this down. If we don't do that, don't bring any of these in, right? In fact, we'll probably find a way to make sure there's copies so that if something does happen to me, that we're all saved somewhere else and someone else is ready to step up into my position and move forward. But regardless, we don't want this going around out there. I don't want you guys going into your local courthouse and saying, here's a criminal affidavit, judge, F you, right? Just give me a little bit of time. Get me these documents, stand back, let me do my work. I don't need much time, but let me do my work. And if it doesn't work, then maybe we'll have to look at something else. But God doesn't make fools. Okay, so So uh, don't try to do it on your own, right? Get them to me, and then maybe we'll plan for the day, and everybody that wants to come down and carry a box in with me, come on down to DC and let's shove this straight up the Supreme Court's whatever.
Yes, absolutely, absolutely. We can do this. We can all get um, just it's simple instructions, you know. And as long as following suit, we don't want trying to code. We're not a code. But
Yeah.
the people, we are code.
There's we aren't a cult. We don't want to be. But I just remembered something, and I have to leave here at 8:30 because the coffee shop shuts down, guys. So I'm on, but there's a very important point that I want to make. Okay, so the way that this works is this is a citizen's arrest. What you're doing is a citizen's arrest. So any person can perform a citizen's arrest for a felony committed in your presence. Felony in your presence. Okay. So it has to be a felony and it has to be committed in your presence. So for all the people that are in prison right now, in prison, we may not be able to get a signature directly from them because these prisons are going to shut it down. They will not let us get the information in, nor will they permit the information out. That's just what they do. You know that as well as I do. So we may not be able to get the affidavits back from all these prisoners. So then we have to figure out something else. And there's a couple different things, okay? If you were present when they were arraigned or you were present when they were arrested, then you can sign because the felony committed in your presence. Okay. So if you were present when they were arrested or you're present when they were arraigned, then you can sign. Okay. So you can do it then. And you could be the witness because you saw a felony committed in your presence. Therefore, you can sign this affidavit on your behalf for the felony that you witnessed. Okay. So there's option one. Option two is if you have a power of attorney for your son, for your husband, for your wife, whatever, if you have a power of attorney, it must be a power of attorney to perform civil action, to initiate a civil action, because the grand jury or this criminal matter is a civil action. It doesn't become criminal until there's an affidavit. So if you have a power of attorney to initiate civil action on behalf of the person that's imprisoned, then you can also sign for that person, even if you weren't present for the arraignment, even if you weren't present for the arrest, you can still sign on his behalf. Okay. But those are the only two things. If you don't have a power of attorney to sign on his behalf for civil matters, or if you weren't present, then we're gonna have to find a different way to do it, right? But we have to have the felony committed in your presence, okay? Okay, and as long as that happens, then you can sign and you can initiate this action on behalf of a party that would be in prison right now. Okay.
Awesome, awesome. That's amazing.
So I just have a couple minutes, you guys. I'm so sorry. I know that today was a little bit more organizing, less questions. Maybe tomorrow I'll try to get a couple in, but I'm gonna have to shut down because they're gonna want me out of here. I do want to say that last night two people blessed me, and I've now got 6 nights covered with my room. Thank you guys so much. I don't know who it was, but whoever it was, I appreciate it so much. And you know, I left last night and I had a couple of ladies that met me as soon as I got done with the video, and they just sat and we prayed for an hour and talked, and it was incredible. And then she just gave me $100, which was my dinner last night. So so I want to say thank you guys so much. How you guys are taking care of me, I appreciate it. And that's the reason why I don't get paid, because I don't want to focus on money. I don't want to make this about that, because that becomes my passion. I want to focus on service and providing the best service that I can to all of you. And if you guys appreciate the service, if you guys like it and want to see more of it, then you guys will make sure that I have the things I need to be able to be successful at this. And we're almost there, guys. So I want to say thank you guys so much for the ones that did help out yesterday. If you guys are able to help out some more, that'd be great. We're going to have some big costs coming up. Okay, big costs, because if we're moving forward now with the affidavit issue, if we're moving forward to correct those, I have to have the ability to print them, right? I have to have the ability to reproduce them and stuff. So there's going to be some costs that are going to be coming up that you guys please be prepared to help when that time comes, and get us over this hump. But this is the last step, you guys. This is the last step. We are going to shove 500,000 criminal affidavits from every single state, every single county up to Supreme Court, and we're going to say to them, what do you want to do about these crimes that are treasonous in nature, that's being committed on your watch by your agents? What do you want to do about it, Supreme Court? Let's make it happen, okay?
All right, brother. Let's make it happen.
This time next week, you guys, we will have something online. We will have those affidavits available, and you guys will be able to access it. We'll figure it out, and we'll get this done. We'll get it done, guys. Get it done.
Well, yeah, we'll definitely have that taken care of very soon. For the most part, you guys should reach out directly. Definitely make sure that you get the affidavits if they're not up online. But we're gonna work towards getting that done with the next few days.
Yeah. Awesome. Thank you guys so much. And here soon, we shall be free. All right, guys? We shall be free. Thank you.
Absolutely. Thank you. This is my
God bless everybody.
Here We Grow.
Here we go. Thank you, brother. Thank you, guys.
Peace.